Judgment in the matter of Tesla against Interdigital Patent Holdings.
Lord Hamblen will explain this judgment.
This appeal raises important issues concerning technical standards. A technical standard allows products made by differing manufacturers to communicate and be used together, promoting the interoperability and safety of new products and systems, as well as encouraging wider investment, innovation and development. The relevant standards involved in this appeal are those set by the European Telecommunications Standards Institute, or ETSI, for use in connection with 5G-enabled cars. Where particular inventions are declared by their owners to be essential to a standard, such that the standard cannot be implemented without infringing them, they are called Standard Essential Patents, or SEPs. ETSI makes it a condition of being included in a standard set by them that the SEP owners undertake to grant a license to implementers covering the use of their SEPs on fair, reasonable and non-discriminatory terms, otherwise known as FRAND terms. The overarching issue raised by this appeal concerns whether an implementer who has the benefit of a FRAND obligation from a SEP owner can proactively bring proceedings in England and Wales requesting the court to declare whether a SEP owner's licensing officer is FRAND if that offer is made with that of other SEP owners through an agent operating a patent pool or a patent platform. The implementers in this appeal, Tesla Inc. and Tesla Motors Limited, together Tesla, wish to launch 5G-enabled vehicles in the UK, Tesla's fourth largest market. In order to achieve this, Tesla require a license to the UK SEPs declared for 5G-enabled cars. Interdigital Patent Holdings Inc., or IDPH, and Interdigital Holdings Inc., or IDH, and collectively Interdigital, are Delaware corporations of the wider Interdigital Group. The Interdigital Group owns a worldwide portfolio of SEPs for the ETSI 2G, 3G, 4G and 5G standards, including certain UK patents relevant to the 5G standard, which Tesla wished to implement. Avanci Vehicle LLC, or Avanci, is a Delaware company which operates a number of licensing platforms which license the patents of those who've signed up to the platform. By paying a fee to Avanci, an implementer would secure a license to use all of the SEPs on the platform, instead of having to negotiate a license with each SEP owner separately. The Avanci platform concerned in this appeal is for the licensing of 2G, 3G, 4G and 5G SEPs for use in connection with 5G-enabled vehicles, the Avanci 5G platform. At the time of the first hearing in July 2024, there were about 65 SEP owners on the platform, including Interdigital, with around 170,000 SEPs relevant to the 5G standard concerned. Avanci does not own any of the SEPs on the platform and, unlike the SEP owners themselves, has not given an undertaking to ETSI to grant a license on FRAND terms. Whilst Avanci maintains that the licensing fee set for the Avanci 5G platform is FRAND, Tesla consider that it is too high and exceeds what is FRAND. In December 2023, Tesla commenced proceedings against Interdigital and Avanci concerning the Avanci 5G platform, seeking multiple declarations from the court that, amongst other things, Tesla are entitled to a FRAND license to all SEPs on the platform, which includes the UK SEPs owned by Interdigital, and that the current platform fee is not FRAND and should be a lower amount set by the court. I shall call these the licensing claims. As Interdigital and Avanci are both located outside the jurisdiction of England and Wales, the licensing claims raise related issues concerning whether the court has power to grant permission to serve the claim out of the jurisdiction, and if so, whether it is appropriate to do so. The High Court struck out the licensing claims. In coming to this decision, the judge, Mr. Justice Fancourt, held that there was no serious issue to be tried against either Interdigital or Avanci. A majority of the Court of Appeal dismissed Tesla's appeal. The majority held that there was no serious issue to be tried on the licensing claims and that the declarations sought by Tesla would not be useful or legitimate. In his dissent, Lord Justice Arnold would have allowed Tesla's appeal. He considered that there was a serious issue to be tried as against both Interdigital and Avanci. He also concluded, like the judge, that the jurisdictional gateways were satisfied in relation to the licensing claims and, contrary to the conclusion of the judge, that the Delaware Court of Chancery was not an available forum to determine those claims. Tesla now appeals to the Supreme Court and Interdigital cross-appeals concerning certain elements of the judge's conclusions, which the majority judgment of the Court of Appeal did not address. In its judgment, the Supreme Court unanimously allows Tesla's appeal and dismisses the cross-appeal. Lord Kitchin and I give the judgment with which Lord Sales, Lord Briggs and Lord Burrows agree. The first main issue is whether there was a serious issue to be tried on the licensing claims against Interdigital or Avanci. The relevant test is whether the licensing claims have a real as opposed to a fanciful prospect of success. As held by the Supreme Court in the case of Unwired Planet International against Huawei in 2020, when interpreting the FRAND obligation and determining what would amount to a FRAND license, the current commercial practice of SEP owners and implementers is highly relevant. In particular, the Court notes the following practices. 1. The growing use of licensing platforms across multiple technical fields and standards. 2. Avanti's own representations that the Avanci 5G platform is FRAND. 3. The practice of certain SEP owners relying on the previous version of Avanti's platform as satisfying their FRAND obligation. And 4. The recognised practical impossibility of negotiating bilateral licenses with each SEP owner included in the relevant standard. In light of this background, the Court considers the following issues arise. First, is there a serious issue to be tried as to whether the FRAND obligation applies to an offer to license jointly through a licensing platform with other SEP owners? The Court holds that there is. Each SEP owner is subject to the FRAND obligation, and there is nothing in the undertaking they gave to suggest that it ceases if two or more SEP owners choose to offer a license of their SEPs through or using a licensing agent such as Avanci. Whilst a SEP owner is not obliged to join or license through a pool or platform, joining a platform like the Avanci 5G platform does not release a SEP owner from the FRAND obligation, and it will be open to any SEP owner on the platform to seek to rely on the availability of platform licenses to satisfy its FRAND obligation. Second, is there a serious issue to be tried as to whether, in respect of Interdigital's UK SEPs, a FRAND license would be a license to the Avanci 5G platform at a FRAND rate? Assuming it is held at trial that a SEP owner remains bound by the FRAND obligation in respect of any SEPs is chosen to license through the Avanci 5G platform, the Court holds that Tesla also has a real prospect of successfully establishing that the only FRAND license of Interdigital's UK SEPs on the Avanci 5G platform is a global platform license, which extends to the whole Avanci 5G platform at a FRAND rate. In support of this, the Court notes that it is Tesla's case that many SEP owners, albeit not Interdigital, rely on the Avanci 5G platform license as satisfying their FRAND obligations. Further, if it's not practicable for implementers to negotiate a bilateral license with all SEP owners on the platform, this is a powerful factor which would support the conclusion that only a license to the whole Avanci 5G platform can be FRAND. There is accordingly a serious issue to be tried. Third, does Tesla have a real prospect of being granted the declarations it seeks against Interdigital and Avanci? Section 19 of the Senior Courts Act 1981 and Civil Procedure Rules, Rule 40, Sub-Rule 20, provide that the court may make binding declarations. The court holds that a court should not be reluctant to make a declaration where it would serve a useful purpose and help to ensure that the aims of justice are achieved. The court emphasises that the power of the court to make declarations is of great utility in proceedings concerning FRAND obligations. It has been used by CEP owners to enforce their patent rights against implementers and by implementers seeking clarity as to what they must pay to secure a license and prevent an injunction being ordered. The court holds that Tesla have a real prospect of securing the declarations they seek, as against both Interdigital and Avanci. With respect to the latter, the claim concerns a legal right, the FRAND obligation, and there is no requirement for this to bind Avanci or for Tesla to have a cause of action against Avanci. Tesla have a legitimate purpose in seeking these declarations. They would serve a useful purpose in allowing an effective challenge of the fee set by Avanci for its platform license. Further, there are no procedural fairness issues which would prevent a court from making the requested declarations. At this stage, it's not necessary for all CEP owners on the platform to be represented. However, they could join any future proceedings if they so wished. Further, Avanci arrived at the applicable fee independently of the CEP owners, and it is the relevant party for any assessment as to whether the platform licence is FRAND. The second main issue is whether the courts of England and Wales have jurisdiction to determine the licensing claims and whether it is the appropriate forum to do so. This gives rise to the following further issues. First, what is the correct characterisation of the licensing claims? Endorsing the reasoning of Lord Justice Burse in the case of Vestel against Access Advance, or Vestel, which has been followed in a number of subsequent cases, the court considers that the licensing claims, properly characterised, principally concern Interdigital's UK CEPs on the Avanci 5G platform. These claims concern what terms will constitute a FRAND licence in respect of those UK CEPs, and their characterisation is not altered by the fact that Tesla argues that only a global licence, also covering foreign CEPs, would be FRAND, nor that the percentage of UK CEPs making up any global licence would be small. Second, were the licensing claims properly served on IDPH pursuant to CPR Rule 63, Sub-Rule 14.2? This rule allows for service of a claim form, quote, relating to a registered right, close quote, at the so stated address recorded at the United Kingdom's Patent Office. IDPH is the owner of the UK CEPs on the Avanci 5G platform. The question is whether the licensing claims relate to those registered patent rights. The court considers that the claims do so relate. The phrase relating to should be given its normal meaning and should not be interpreted narrowly to mean substantially or really about. Third, do the licensing claims against IDH pass through either Gateway 3 or 11 of CPR Practice Direction 6b? In respect of Gateway 3, which concerns serving a, quote, necessary or proper, close quote, party to a claim, which has otherwise been or will be appropriately served, if IDPH was properly served within the jurisdiction, then Avanci would be a necessary or proper party to that claim. So too would IDH, as it was IDH that gave the relevant undertakings to ETSI on behalf of IDPH, the owner of the UK CEPs, that it would comply with the FRAND obligation in respect of them. Accordingly, the licensing claims against IDH pass through Gateway 3 and could be served on IDH out of the jurisdiction in reliance on it. In respect of Gateway 11, which concerns the service of a claim form where the subject matter of the claim, quote, relates wholly or principally to property, close quote, in the UK, the court considers that the licensing claims do relate to property within the UK, being UK patents. This conclusion aligns with the consistent line of authority since the Vestel decision, which has considered Gateway 11 available in implementer commence claims requesting a declaration as to the terms of a global, not just UK, FRAND licence, and reflects the correct characterisation of the claim. Fourth, whether there is a more appropriate forum than England and Wales to determine the licensing claims. For the purposes of assessing forum, the correct characterisation of the licensing claims are that they are claims about the licensing of Interdigital's UK CEPs on the Avanci 5G platform, and what the FRAN terms for a licence of those UK CEPs would be. By focusing on whether the Delaware Court of Chancery was an available forum for a global licensing claim, generally, rather than this characterisation, the judge had mischaracterised the claim, and this materially impacted his approach to the expert evidence. Accordingly, Lord Justice Arnold was correct to re-evaluate this evidence. The court agrees with his conclusions that the Delaware Court of Chancery was not an available forum to hear the licensing claims. The expert evidence indicated that on the balance of probabilities, the Delaware Court would not determine a FRAN claim based on non-US patents like Interdigital's UK patents. Finally, the court considers that there are no good or compelling reasons to refuse permission to serve for licensing claims outside of the jurisdiction.